Hello, it's Phillip Taylor speaking from Richmond Green Chambers. I'm talking about patents, or patents, depending on how you wish to pronounce them. And it's about this book. There's the Flickr reference there, and this is the book itself. It's a heavy one. It's the CIPA Guide to the Patents Act. That CIPA is the Chartered Institute of Patent Attorneys, and this is the 6th edition, published by Sweet and Maxwell. It's a heavy book, you can see the side of it, and it's 1700 pages, I think, altogether, or 1500. No, it's 1500 pages altogether. It follows very much the Sweet and Maxwell style, with paragraph numbers at the sides, a very large number of cases right at the front, which you can see there, and a very useful preface from which I've taken some comments for my appreciation. There's also a very good index, a very standard but solid index at the back. It's a heavy book, and of course, dealing with statutes, it's going to have a huge amount of detail in it. There are, of course, lots and lots of references to the various pieces of legislation and guidance of various sorts. You've also got, which comes with the book, a little note keeping you up to date with updates, and it is certainly well worthwhile registering for the updates. Now, the reference I've given this book is the definitive word, the definitive work on how patent law is constructed. Because what we're looking at, obviously the Act of Parliament and the various pieces of legislation state what the law is, and then we have to see how the construction actually occurs. And what I've said is the following. When faced with a question of patent law or practice, this 1500-page volume, to which you should really turn, whether you're a patent attorney, solicitor, barrister or other practitioner, particularly in IP, is the final word, and quite clearly it is the best, but it is not an easy read, so don't think there are any easy ways out with this particular subject. It's the first new edition, in the 6th edition, of a work known to the practitioner as the Black Book, since the publication of the 5th edition was in 2001, and it's been long awaited. And it's explained in the preface to this monumental and authoritative work of reference that the 5th edition covered the further important changes which had taken place with the amendment rules in 1999, which were followed by further changes in the relevant Act and the rules to meet the implementation of the European Biotechnology Directive. And for the 6th edition, we've got the implementation of the Patents Act 2004 and the EPC 2000. So we've obviously got a nice broadening of this legislative programme. Also incorporated is the completely revised form of the rules in the Patent Rules 2007, which of course is one of the great benefits of the book. An interesting perspective, of course, on the evolution of and the significance of the Black Book is offered in the foreword by Lord Justice Jacob, who writes as follows. Says, "Scholarly thought and erudite writing was for others," he points out, "not patent agents, who tended to be viewed by themselves as well as others as rude mechanicals. The patent agent of yore could not have produced the Black Book," he adds. "Only with the advent of the patent agent or scholar was it possible." An interesting piece of history, if you like, about the way that this area of law has developed, and it's a very important one in the 21st century. The current Black Book has been produced by a team of just such scholars, and as remarked by Jacob, it's good to see them working with other members of the IP profession. In response, therefore, to the surge of inventions and inventiveness characteristic of the 20th and certainly the 21st century so far, which stand certainly on the shoulders of the inventions of the 19th century, it's not surprising that the profession of patent attorney has come of age. And Sweet and Maxwell clearly see this and say that the 6th edition of the Black Book offers thorough and practical coverage of the current legislation and case law in this increasingly complex field. And therefore it's an essential guide containing all the tools needed to protect the rights of your clients. And as I said, this has become a much more important and higher level area for lawyers and anybody else as society changes. And in addition, of course, to a comprehensive perspective on law with reference to hundreds of key case decisions listed in quite detail at the front, there are detailed commentaries on the current law and practice under the Patents Act 1977, the Patent Office Rules 2007, and subsequent amendments. Relevant sections of the Copyright, Design and Patents Act 1988 are also analysed, and you'll find that quite useful, although that particular act, the CDP, is a little bit old now. There is also new coverage on a number of key areas, including supplementary protection certificates, patent office opinions, restorations, entitlement and inventorship. And there's thorough examination of other recent major developments, including computer software patentability, biotechnological inventions, pharmaceuticals, industrial application and medical treatment. So it's very much a creature of the 21st century. And as Jacob observes, the future looks exciting. He says, "Those who do not want to get lost as they enter that future had better get the Black Book." That's his conclusion, and how right he is. Thank you very much. Bye-bye.